Fifth lecture note. The title of this lecture note is Forms or Sources of Law. We are going to look at this in three aspects. The first, the concept and kinds of forms of law. The second, the system of legal acts in the Russian Federation. The third, lawmaking in the Russian Federation. Let us look at the first aspect, concept and types of forms of law. Forms of law are understood in two senses, that is, as ways of fixing an external expression of legal norms, law, bylaws, and as the source of ontological law, that is, the will of the people, the will of the ruling elites. Classifying the forms of law, it is necessary to note the following types. The first types, oral. Here, rules laid down in the minds of people in automatic mode, legal custom, principles, axioms of law, obvious, basic rules that do not require fixing for their legitimacy. The second, written, having a sign of formal certainty, which in turn are divided into types 2.1, to the case, in Latin ad hoc, creation of a norm for a certain event, that is a precedent, Latin precedent, going ahead, preceding the decision of the law enforcement body in the case, the justification of which is used later when solving similar cases by bodies of equal or lower level. That is, if the actual circumstances coincide, there is a reference to the case described earlier. A doctrine, text of authoritative scientists, a normative contract. Type 2.2, permanent, law normative legal act, designed for an indefinite range of subjects and situations. Let us look at the second aspect, the system of legal acts in the Russian Federation. A normative legal act is a written official document adopted by a law-making entity within its competence that contains, establishes, changes, or cancels the norms of law. The system of normative legal acts of the Russian Federation at the federal level has the following structure. The first, the Constitution of the Russian Federation, that is, the basic law. This term is also used in the constitutional context. The second, federal constitutional laws, which provided by the Constitution. In some foreign countries, such laws are referred to as law, organic law. Amending it. The third, laws. Officially, they can be called federal law, law of the Russian Federation, codified acts, codes and basis of legislation also refer to this form. The fourth, bylaws, decrees of the President of the Russian Federation, resolution of the government of the Russian Federation, resolution of the chambers of the Federal Assembly of the Russian Federation, orders of ministries and departments, instructions, and so on. A law is a normative legal act adopted in accordance with the established procedure by a legislative body or directly by the people, which has the highest legal force and regulates the most important social relations. The higher the normative legal act in the structure, the more legal force it has. The normative legal acts listed in this structure are collectively referred to as legislation. In a broad sense, in a narrow sense, these terms applies to the laws themselves. In turn, there is also a similar regulatory hierarchy at the level of the federal subjects, constitution of the subjects of the Russian Federation, laws of the subjects of the Russian Federation, bylaws. At the level of municipal law making, the term law is not used in Russia. Let us look at the third aspect, law making in the Russian Federation. Lawmaking Lawmaking is the legally formed activity of authorized entities to create, change, or cancel normative legal acts. The main criterion for classifying types of lawmaking is its subjects. This aspect can be distinguished: direct lawmaking, that is, the adoption of laws and other decisions of the legislative value in the referendum. The law refers to the activity of higher state legislative bodies and legislative bodies of subjects of federation to pass laws. The various rulemaking authorities regulated Let me come again. The various rulemaking authorities delegated legislation, municipal rulemaking, local lawmaking of management bodies of legal entities, contractual lawmaking of equal entities that have the right to issue regulations. To stabilize the law, a social institution was invented: lawmaking activity. The idea of this activity is a sieve, that is a filter. The right has filters that the rules pass through, and only the most correct and most important ones remain and are placed in the system. Let us consider this principle on the example of the lawmaking process. All 5 filters, they are called the stages of the legislative process. At any stage except for publication, the bill can be rejected. The first stage, legislative initiation, the range of subjects that have it is limited. In Russia, they include the President, the Federation Council, members of the Federation Council, deputies of the State Duma, the government, the legislative bodies of subjects in matters of their jurisdiction, the constitutional and supreme courts. The second stage, reading. The bill is read at the State Duma level 3 times. There are exceptions for a budget bill that passes 4 hearings. Third stage, a bill approved by the lower house of parliament, the State Duma, is approved by the upper house of parliament, the Federation Council. Fourth stage, signing of the law by the head of state. The President of the Russian Federation signs the bill or has the right to veto its adoption, which requires a qualified majority of votes of both houses of parliament to overcome. The fifth stage, official publication. Regulations that are not officially published are not applicable. And with that, we come to the end of the lecture note. Thanks.